Health experts say we're now starting to see the surge in coronavirus cases from the Thanksgiving holiday weekend. And now, just like we saw in March, employers are taking some extra precautions to keep everybody safe. We're going to go in depth about those changes that owners are taking right now and what they can legally ask of their employees. Coming up next on Spectrum, Bay News 9. Welcome back to Spectrum Bay News 9. I'm Rick Elmhorst. It's time to go in depth this afternoon, and we're taking a look at another issue revolving around the pandemic. Getting together with friends and family over the holidays is typically a festive and really joyous occasion, but with the rising number of cases of coronavirus posing a threat nationwide right now, it's now a serious workplace concern. And joining us to discuss this is attorney Robert Shimberg from the law firm Hill Ward Henderson in Tampa. Robert, welcome to In Depth. Thanks for joining us today. Hey, before we get to the subject at hand, really, which is how much can employees require of what their employees are doing, say, off of work to try to keep everybody safe, I want to talk to you about what you've been doing so far with your law firm to deal with COVID with all of these companies out there.
Sure. So first of all, thank you for having me. So starting back in February of this year, as issues started really coming to the forefront relating to COVID, we had a number of clients that had issues beginning with employment-related issues, segueing into contract-related issues, insurance-related issues, construction-related issues, of course, issues relating to the PPP and other different loan and relief packages that were available to them. And really, as we got further into the pandemic, a tremendous number of issues relating to policies and procedures at the workplace relating to what to do if there was a employee who had a positive COVID-19 test, what to do from the standpoint of quarantining or recommendations for quarantining of other employees, what to do from the standpoint of notification of customers as well as employees, and kind of running the gamut of all types of employers in and around the Bay Area and the state of Florida. I mean, that's just a flavor of the issues. I can tell you that COVID-19 has really touched many, many areas within the legal practice and has had an impact on a significant number of issues, legal issues.
Robert, we've got a fascinating issue to talk about today, and that's the issue of what if an employer says, hey, I want you as employees to limit what you do off the job to try to keep everybody safe from COVID-19. What if they told employees, we don't want you to have, big holiday gatherings, just don't do that? Is that something that legally they can do?
So yes, they can. And what we would recommend is, generally the framework that you would want to work within would be, first and foremost, CDC guidelines. And what's the CDC guidelines saying with regard to, gatherings and the number of people that are recommended to be at a gathering. At the same time, look at your local city or county ordinances that may be in place, and then whether there's any state recommendation or ordinances that are in place. But yes, certainly the employer can say to the employee from a health and safety considerations, we want to be consistent with what's in the CDC and or other recognized guidelines, so we can try to minimize the risk of COVID-19 coming into the workplace.
Does an employer actually have the legal right to maybe discipline somebody or put them into some kind of a off-site quarantine if they find out that they have been at some kind of a large gathering? Let me give you an example. Somebody was just telling me about another TV station, and the TV station would see where employees on their social media were posting pictures of themselves being at a large gathering, and they told those people they had to stay away from work for 14 days, being a kind of a quarantine. Can they do that?
So again, it's going to primarily come down to what are the policies in place that the employer has set up, and have they clearly communicated it to the employees and said, these are our expectations, these are consistent with the CDC or with the local guidelines. They've given people, appropriate notice of what those are, and those have some, appropriate connection to trying to minimize bringing coronavirus into the workplace. Then absolutely, that's something that they can do, and they can say, for instance, if you're not going to follow something like that, then we're going to ask that you appropriately quarantine before you come back into the workplace.
One of the big issues here as well is HIPAA. It's a medical privacy law. We're all familiar with that. So an employer, it seems like they can only ask so much information about a worker's health before they get in trouble with HIPAA. So, for example, a lot of workplaces, they require people to take their temperature every day and to maybe fill out some kind of a form that says, okay, my temperature is not above this point and I haven't been around anybody that I know of with COVID. Is that something that you're seeing a lot of your companies do?
Absolutely. Absolutely. And again, it goes back to the reasonable precautions that are being put in place with regard to trying to minimize the likelihood that COVID-19 comes into the workplace, and the fact that you are making these protocols and procedures known to your workforce as well as others that may come into your business. You're letting it be known ahead of time. And as long as you're doing that, you're going to generally be okay in asking the people to follow through on providing that type of reasonable information. Have I been out of town? Have I been in an area where there's a high incidence of, COVID-19 in the last couple of days? Have I been on an airplane? Those type of questions.
Attorney Robert Shimberg, thanks so much for joining us on In Depth today.
Thank you.